Well, this is a document filed today, April 26, 2022, document 221. Defendant Netflix Incorporated applied in support of a motion to compel production of documents responsible to subpoena to Michael Griesbach. Part of this is redacted. For more than 15 years before he became counsel to Mr. Colborn, Michael Griesbach had directed involvement with the events that gave rise to Mr. Colborn's lawsuit. Netflix subpoenaed Mr. Griesbach as proper, and he seeks relevant documents that easily meet applicable standard for discovery. In response, Mr. Griesbach blusters and accuses, but fails even to address applicable standard for discovery under federal rules of civil procedure. He focused instead on whether the documents would be admissible by trial and on Wisconsin's advocate witness rule, neither of which govern whether the documents must be produced in the first place. Further, he, on the one hand, relies on demonstrable false contention that his books analyze publicly available information, which simultaneously acknowledging that he relied on admittedly non-public information. Netflix does not seek to turn Mr. Griesbach into a witness in the matter. Netflix has not sought to depose Mr. Griesbach or indicated any intention of calling him as a witness at trial. Mr. Griesbach owns direct involvement in underlying facts over the course of more than 15 years before Mr. Colborn retained him as a legal counsel, make his documents discoverable. Further, Mr. Griesbach cannot now cloak himself in a production of Wisconsin's reporter privilege because he waived any production in the last 2 ways. Mr. Griesbach failed to assert the privilege of his objections to the subpoena. Second, by becoming plaintiff's legal counsel in the case, Mr. Griesbach abandoned his role as an author and became an advocate and legal counsel not protected by a reporter's privilege. Ha 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 ha. Further, Mr. Griesbach cannot cloak himself in protection of Wisconsin's reporter privilege because he waived his protection in at least 2 ways. Mr. Griesbach failed to assert the privilege of objection to subpoena. Second, he became plaintiff's legal counsel. I already read that again, didn't I? Because Mr. Griesbach's position fails to provide any valid basis for failing to operate the subpoena, the court should grant Netflix's motion to order Mr. Griesbach to comply. Argument. Mr. Griesbach has not shown the subpoena as unenforceable. As Netflix has shown the motion to compel, the subpoena is proportional to the needs of the case and seeks relevant discoverable materials unavailable elsewhere, satisfying federal rules of civil procedure 26 and 45. Accordingly, the court should now grant Netflix motions considering the totality of the circumstances, weighing the value of the material sought against the burden of providing it, taking into account society's interest in furthering the truth-seeking function in the particular case before the court. The subpoena meets relevant standard for discovery. Mr. Griesbach contends that under the federal rules of evidence, the evidence which Netflix seeks is irrelevant. Therefore, none of the materials the subpoena which seeks would be admissible in trial. Which, while Netflix disagrees with both contentions, whether the materials requested may ultimately be admissible at trial is not the question. Federal rules could not be clearer on this issue. Information within the scope of discovery need to be admissible to evidence to be discoverable. Relevance in discovery is broader than relevance in trial. During discovery, a broad range of potentially useful information should be allowed when it pertains to issues raised by the parties' claims, internal marks, and citations submitted. Thus, only issue for the court to determine whether the subpoenaed material meet the broad standard of relevance and discovery, and Netflix has shown that they do. Mr. Griesbach insists the thoughts about evidence are not evidence themselves, essentially arguing that neither his views on Stephen Avery's guilt or innocence nor his views of allegations that Mr. Colborn planted evidence to ensure Mr. Avery convicted are relevant. But even assuming that is true, the truth or falsity, Mr. Avery's frame-up theory, and the accuracy of Ma'am's portrayal of that theory are just two of many issues in this lawsuit. In addition, providing defendants somehow mischaracterization of Mr. Avery's accusations, such that MAM misled viewers. Mr. Colborn must prove challenge statements were defamatory, and they harmed his reputation, and contrary to Mr. Griesbach's contention, the impressions and opinions contained in the responsive records are relevant to this case, in this issue, as even Mr. Colborn's counsel has admitted. Specifically, how both underlying court proceedings and later MAM impacted opinions of Mr. Colborn, held not only by Mr. Griesbach but also others in the community, many of whom Mr. Griesbach knew and possibly interviewed for his books, are relevant to Mr. Colborn's reputation and his damages. I have no clue what that was supposed to say. Although, also contrary to Mr. Griesbach's suggestions, examples discussed in the motion were just that, and are not only proof that it is relevant, discoverable materials in both Innocent Killer and Indefensible. Mr. Griesbach describes in nearly identical language how the Halbach murder was the chief topic of discussion at the local Greasy Spoon during the Teresa Halbach investigation and Mr. Avery murder trial, and that everyone had an opinion, split between those who thought Mr. Avery was guilty and those who thought he was framed. Quoting blah blah. Joe and Tammy as examples of each side, Innocent Killer, relevant to Mr. Colborn's reputation. Mr. Griesbach also wrote in Innocent Killer that number of people who were suspected the police set Steve again rose sharply. When news broke that Mr. Colborn and James Link, who both had been deposed in Mr. Avery's civil rights lawsuit shortly beforehand, had discovered the key to Miss Halbach's SUV in the sixth search of Mr. Avery's trailer, Innocent Killer 212-213. He then observed that the news of Brendan Assey's confession even changed the views of some of the most conspiracy-minded people in town, convincing them that their former hero was guilty after all. But for those with unshakable conviction that the police were corrupt, Brendan Assey's confession only solidified their views. At these expertly writing, Mr. Griesbach was hardly any other person. He researched and wrote 3 books about the events giving rise to the lawsuit, and is better positioned than most of the engaged community's opinions about law enforcement in general, Mr. Colborn particularly. He literally wrote down and saved what people told him. Thus, Mr. Griesbach is uniquely positioned to have relevant evidence. His notes and drafts and manuscripts of his books, as well as written communications about relevant issues, are likely to contain contemporary evidence and community's views on the underlying facts of this case in general and Mr. Colborn in particular. Moreover, the subpoena is not limited to materials containing Mr. Griesbach and others' opinions. It seeks documents and communications regarding Mr. Griesbach's books, MAM, underlying events such as Mr. Avery's 2003 exoneration and search warrant for the Avery property that Mr. Griesbach drafted, communications between Mr. Griesbach and other MAM and related topics as the issue of this case. Those documents and communications are reasonably likely to contain not only evidence relevant to Mr. Colborn's reputation and his ability to meet unflattering speech with the counter-speech, but also relevant information regarding the facts underlying the lawsuit, and they are likely to refer to other sources of admissible evidence. Mr. Griesbach has not shown and cannot show otherwise. The subpoena material are not available publicly or from others. The opposition falsely and repeatedly states that in undisputed that Mr. Griesbach's books are based entirely on his own impression of publicly available records. Not only is the assertion very much disputed, it is demonstrably false, and even if there were true, it would not render the materials irrelevant in discovery context. The opposition repeatedly cites Mr. Griesbach's affidavit as support for the claim that his books based his books solely on public information. The affidavit itself has no such thing. Footnote: as Mr. Griesbach already knows, however, Netflix is not seeking published versions of Mr. Griesbach's books. Those are already in Netflix possession. Moreover, and Mr. Griesbach demonstrated a willingness to negotiate the scope of the documented production, Netflix may have concluded It's only need him to produce certain publicly available court records. Instead, Mr. Griesbach took a hard line that he would not produce anything. Shutting down constructive discussion about the Netflix might narrow his request. Rather simply authenticate 6 exhibits, 5 of which are publicly available records on which the copy of one of Mr. Colborn's interrogatory responses. Mr. Griesbach does not provide any evidentiary support for the contention that his books are entirely analysis of public information. In his books, as discussed above, Mr. Griesbach wrote the first about his conversation with various people, both named Sumenos, and key facts about their attitudes and shaped Mr. Colborn's reputation. Further, in his Killer, Mr. Griesbach recounts in detail his non-public actions and conversations with Manitowoc County prosecutor regarding both Mr. Avery's exoneration and the later murder case against him. Medicine Killer, pages 127 through 170. Mr. Griesbach describes one conversation he had with Dennis Vogel, the former attorney who prosecuted Mr. Avery in 1985, including one in which Vogel asked if there was anything in the Avery file about Gregory Allen, the actual rapist. There was. He also described arriving in the Avery salvage yard after the discovery of Teresa Halbach's SUV, gathering information from detectives such as search warrant, Mr. Griesbach's false contention that he had no special powers allowing him access to the material. Only access came from reviewing public materials, therefore belied, and by with the published showing precisely the opposite. Mr. Griesbach also claims the evidence Netflix cited to show he likely has relevant, responsive materials does not suggest that he has non-public information to discover. And discussed above, however, there is plenty of evidence, including but not limited to the examples cited in motion, suggesting that it's highly likely that Mr. Griesbach has responsive, non-public materials. For example, Mr. Griesbach claims a Netflix citation of an email he forwarded to Manitowoc County Sheriff's Office does not indicate his non-public records because the email attached to publicly available radio interview was obtained via a subpoena of the Sheriff's Office. This is not, Mr. Griesbach suggests, a speculative attempt to part of the Netflix to create an impression that Mr. Griesbach must be hiding something, but rather part of the proper support of the conclusion. Mr. Griesbach is likely to have responsive, relevant, and non-public materials. The email shows Mr. Griesbach used his private email address to communicate with others about topics relevant to his litigation, and therefore is likely to possess other non-public relevant communications. In this vein, Mr. Griesbach also attempts to downplay his participation in and a knowledge of underlying events in the issue of this case. Mr. Colborn's receipt of reporting to the superiors about a phone call in Manitowoc County Jail that he indicated Mr. Avery's 1985 rape conviction was in error. Mr. Griesbach acknowledges he must, and he was deposed about the call on Mr. Avery's civil rights lawsuit, but points to his testimony that he did not have personal knowledge of what Mr. Colborn did with the report about the call, but that he recounted the impression. That was what people were saying about it. While the testimony may constitute hearsay is discoverable. What's more, the subpoena seeks documents and not testimony. The documentation of which people were saying to Mr. Griesbach on this topic or relevant discovery would likely lead to admissible evidence. Even taking all of Mr. Griesbach's criticisms and the Netflix factual citations as true, those citations still support the conclusion that Mr. Griesbach is likely to have responsive non-public documents and communications, or at minimum, the materials that could lead to information relevant and admissible. Absolutely, certainly the third party has responsive materials and not required to support subpoena, as the Seventh Circuit put it. The trouble is, when discovery has not been tried, no one can say for sure whether it is going to be futile or not. The expectation that it will be futile is therefore not certainly the justifies cutting off party discovery rights without any effort to satisfy them in the most essential particulars. Netflix has shown it is reasonable to believe that Mr. Griesbach has relevant discovered materials, which is all that is required. Finally, Mr. Griesbach claims that he need not comply with subpoena because Netflix has issued document subpoenas to persons who may have direct knowledge of the information it seeks. The argument is both irrelevant and incorrect. For the reasons stated herein, the information is not available from other sources. What more, Netflix has not issued document subpoenas to any third parties other than the Manitowoc County Sheriff's Department, including those individuals listed in Griesbach's opposition. And even if those witnesses possess some of the same information, the Seventh Circuit has held that the improper denial motion compelled based on only the bare representation that the deponent knew nothing about the case and that the other deponents knew more. Mr. Griesbach has not made his burden to show subpoena is overly broad or utterly burdensome. Mr. Griesbach acknowledges that the court must determine whether the burden imposed as subpoena exceeds the benefit, and notably does not dispute the burden resets upon the objecting party to show particularly discovery request improper. Another footnote, Netflix co-defendant served the subpoenas to Mr. Griesbach references in any event. As clear as subpoenas served on Mr. Griesbach, none of the individuals subpoenaed by Netflix co-defendants seek the same information as subpoenaed in its issue. How the subpoena would have burdened him, he does not provide any facts to show that the burden on him comply with the subpoena would outweigh the benefits Netflix. The other defendants and society's interest in furthering the truth-seeking function in a particular case before the court. Instead, the opposition makes only a vague reference to the burden placed on Mr. Griesbach searching through documents dating back nearly 20 years. And any relevant statement in defense when Mr. Colborn did not watch Making a Murder somehow tips to the balance of the hardships in Mr. Griesbach's favor. Mr. Griesbach provides neither specific details of the burden he would bear nor sworn testimony regarding any such alleged burden. This falls far short of making necessary showing, which typically requires affidavits and others affirmative evidence supporting the parties' assertions of burden. Mr. Griesbach affidavit merely authenticates documents and is not contained in discussion any burden might face enforced compelling subpoena. Mr. Griesbach's status as counsel does not excuse his refusal to comply with subpoena. Mr. Griesbach's opposition relies heavily on argument that the subpoena is improper in light of his role as counsel for Mr. Colborn. He invokes white constitutional notions and erodes the right of the effective counsel, which notably does not apply in civil litigation, distract from the substance of an argument, which can be distilled in disbelief. The right to effective counsel is a constitutional right that belongs to criminal defendants. Rooted in the Sixth Amendment, there is no right to counsel in civil cases. That by becoming counsel by record, Mr. Griesbach somehow insulated the relevant records from the reach of the discovery. The law on this issue, however, directly the contrary. As Netflix demonstrated in its opening brief, Mr. Griesbach entirely fails to address no specific special privilege or immunity shields in his person discovery simply because he or she is an attorney, or even an attorney for a part of the suit. Attorneys who fact witness cannot complain harassment under due burden which the opposing party seek discovery from them. Even a cursory review of this case law Mr. Griesbach cites reveals that the authority is entirely impossible. Rather, in opposition strings together a series of red herrings, including the ethical and legal restrictions that attorneys testifying witnesses for their clients' case law concerning motions disqualifying opposing counsel. None of these relevant because Netflix has not subpoenaed Mr. Griesbach for a deposition, listed him as a child witness, or filed a motion to disqualify him. Netflix has simply reserved Rule 45 subpoena Mr. Griesbach seeking documents and communications in his possession that are relevant to the case and or could lead to discovery of admissible evidence. Therefore, the law restricting attorneys' ability to trial witnesses in his clients' cases would require recusal or disqualification of attorney witnesses simply not before the court. The questions of whether counsel may be posed is distinct from from the question or whether he should be disqualified because of his role as witness. But even if the law were irrelevant, even attorneys for parties, have no telematic immunity from discovery. The mere fact that an individual employed by a party in a licensed practice law does not insulate from discovery. Mr. Griesbach has, by his own admission, played a significant role in some of the evidence depicted in MAM at issue in this case. Innocent killer, the extent of the producing irrelevant, non-privileged materials that subpoena seeks might affect his representation of Mr. Colborn and in a quandary of which Mr. Griesbach is entirely responsible, and would be fundamentally unfair to resolve the quandary and depriving Netflix of evidence of which is entitled. Mr. Griesbach took a representative knowing that he was deeply involved in Stephen Avery saga. Only had been involved in the Avery story myself, perhaps, then I could have simply enjoyed the craftsmanship of making a murder. He could not avoid his responsibility under the federal rules of civil procedure to comply with subpoena by taking a representation. Mr. Colborn, Netflix is now advocating for disqualification of Mr. Griesbach, but his choice must be between his ongoing representation of Mr. Colborn, who has two other attorneys at different law firms, and his disclosures, discovery, evidence, law, clear the truth, evidence, and paramount. Mr. Griesbach's long waived protection they may have once have been afforded him by Wisconsin's reporter privilege. Mr. Griesbach claims the first time in his opposition to materials responsive to the Netflix subpoena are protected from compelled disclosure of Wisconsin reporter's privilege. Griesbach failed to object to Netflix subpoena on the basis of this or any other privilege, such as objection at this stage untimely, therefore waived. There is not only, though perhaps even more significantly, Mr. Griesbach also waived any claim to reported privilege he may have by joining Mr. Colborn's legal team in 2018. Federal Rule of Civil Procedure 45 allows third party served with subpoena to serve with written objections in the subpoenaing party, but the rule also requires that person withholding subpoenaed information under the claim that is privileged especially make that claim and describe the nature of withheld responsive material. What's more, Seventh Circuit case law is clear. Rule 45 requires that the recipient of subpoena to raise all objections at once, rather than stage branches, so that discovery does not become a game. Charges opportunity to raise a specific privilege-based objections and original objections. As a result, charges did not timely raise the privilege objections with the specific needed to preserve the objections. Failure to comply results in waiver. Here, Mr. Griesbach procedurally waived his ability to seek protection of the reported privilege for the last two reasons. First, he failed to object to Netflix subpoena on the basis, including the reported privilege. Mr. Griesbach offered no excuse for his failure to raise the privilege and objections in the first instance. Thus, according to Seventh Circuit case law, privilege is waived. Second, in neither objection to Netflix subpoena nor is the opposition brief does Mr. Griesbach indicate whether any documents have withheld pursuant to privilege, let alone describe the nature of such documents as required by Rule 45. Because Mr. Griesbach procedurally waived his privilege, the court need not determine whether the Wisconsin reported privilege statute applies to him. But even assuming for the sake of the argument the privilege did apply to one point, it certainly no longer does. Mr. Griesbach subsequently waived his protection when he joined the case of counsel of record for Mr. Colborn. Defendants served a subpoena on a filmmaker for a production of unpublished responsive materials related to the production of a documentary that portrayed events in which were underlying the subject matter of litigation. When he subpoenaed, however, filmmaker had already joined plaintiff's litigation team as counsel of record. The filmmaker turned attorney thus refused to produce the materials responsive to the defendant's subpoena on grounds that the materials were protected from compelling disclosure. Under the Illinois reporter privilege statute, the court assessed whether the filmmaker reported privilege by joining plaintiff's legal team. The court uniquely found that the privilege had been waived. When he failed to appear in plaintiff's case and abandoned the role of reporter and transitioned to the role of legal advocate, Hill chose to become timely involved in the plaintiff's litigation and possible joining plaintiff's legal team. Such in the reporter privilege context will be beyond scope of the statute. With footnotes. Whatever protection under the statute Mr. Griesbach may once have been entitled to as author prior to joining Mr. Colborn's legal team, he waived it by becoming counsel of record. Reporter privilege status were clearly not meant to be used as vehicle for a party to initiate litigation and retroactively use reporter privilege to keep information out of discovery. Ironically, the court in statement closed with this note. This opinion is premised on a unique set of facts that was subject unlikely to recur. A journalist converted to an attorney representing the party in a civil action premised an original jurisdictional effort. Historic has now repeated itself, knowing that the counsels are different results. Conclusion: for the reasons and for all the reasons set forth in his motion, Netflix respectfully requests that the court issue an order compelling Mr. Griesbach to comply with this subpoena. This date, 26th of April, 2022. Well, this is document 2 of the 4. I'll bring the next ones to you soon.